As we may be aware, caution has been thrown into the wind with the developments in Rivers State. And more worrisome is that the people remain at the receiving end in the ensuing political impasse. It must be stated that the situation in Rivers State is very worrisome and has the potential to lead to a breakdown of law and order. The political actors have elected to throw caution in the wind, as evidenced by the defection of 27 Rivers State House of Assembly members. The defection of these 27 lawmakers from the Rivers State House of Assembly has caused a division in the People's Democratic Party in Rivers State. And as such, they cannot eat their cake and have it. The provisions of the law are quite and very explicit in this regard. Therefore, this group of errant lawmakers attempt to use the court's instrumentality to subvert justice in an aberration that all well-meaning Nigerians must resist, and indeed resist. This is on the heels that we have it on good authority that these lawmakers have planned to approach the courts tomorrow to challenge the legality of the letter sent to the Independent National Electoral Commission, INEC, to conduct by-elections to fill the vacuum created as a result of the defection of these 27 lawmakers to another political party. They have approached Justice Okorowo of the Federal High Court in Abuja to rule in their favor in contravention of the NGC's direction on judicial practice of lower courts, not overruling the Supreme Court. That's pretty worrisome. Supreme Court has given a judgment, and the lower court wants to overturn or override the judgment of the Supreme Court. The same Justice Okorowo restrained the Independent National Electoral Commission, INEC, from proceeding with the trial of the suspended Adamawa Resident Electoral Commission, Hudu Yunusa Ari, over his role in the March 18th of year 2023 governorship election in impasse in the state. Justice Okorowo also restrained the Economic and Financial Crimes Commission, EFCC, Independent Corrupt Practices and Other Related Offenses Commission, and the Department of State Services, DSS, from detaining Senator Abdulaziz Yari, that is the former governor of Zamfara State, pending the hearing and determination of the motion on notice. This is history. The courts must tread carefully to avoid being seen as willing collaborators in subverting justice. Recently, the judiciary has been under intense scrutiny about its involvement in politics. We're all living witnesses to some of the rascal judgments given. We have witnessed court judgments that defeat common sense and complicate matters in states of the country. This trend has threatened the judiciary's reputation as the dispenser of justice, protector of the rights of the people, and guardian protector of the constitution of the state, that is the state of Nigeria. This is so worrisome, and why the onus lies on the judiciary to redeem its image using Rivers State as an avenue. The Center for African Liberation and Socioeconomic Rights, CALSER, is calling on the lower courts not to allow it to be used to undermine the stability of the country by rejecting the overtures from the 27 defected lawmakers in the Rivers State House of Assembly. We have it on good authority that these lawmakers and their patrons have boasted publicly about their influence in the judiciary and the possibility of the court doing their bidding, not minding whose ox is God, not minding the adverse effect it will have on the masses, not minding on the breakdown of law and order. We find such positions undemocratic and must be resisted by the judiciary by rising above the board. The judiciary must not be seen as an instrument politicians can use at will to destabilize the country. The position of the Supreme Court is clear about defection from one political party to another. We will now visit the Nigerian Constitution. Section 109, subsection 1 and subsection G of the Nigerian Constitution clearly states that a member of a House of Assembly shall vacate his or her seat in the House if being a person whose election to the House of Assembly was sponsored by one particular political party. He becomes a member of another political party before the expiration of the period for which that House was elected. In simple layman's language, if you belong to party A and you win an election on that ticket and then you decamp or you move or whatever it's called to another political party, that position you held or you are holding in the previous political party becomes vacant as soon as you decamp from that political party to another. We must recall that in 2022, a federal high court in Abuja sacked 16 Ebonyi State House of Assembly members for defection. The court held that the movement breached Section 109, subsection 1, subsection G of the 1999 Constitution as amended, providing that defector legislators are not allowed to retain their legislative seats. This is clear. The same provisions were also applied in Cross River State, including the Federal House of Representatives. Suppose this is the position of the 1999 Constitution of the Federal Republic of Nigeria as amended, again in Section 109, subsection 1, subsection G. In that case, the lower courts do not have the jurisdiction to entertain any matter of defection from one political party to another. Clear and simple. The Center for African Liberation and Socioeconomic Rights, CALSER, wishes to remind the lower courts at this point that any attempt to entertain the planned suit by the 27 defected members of the House of Assembly will amount to turning the law upside down on its head. Therefore, we are firmly convinced that the 27 defected lawmakers do not have any local standard to approach the courts to challenge the legality of the letter sent to the Independent National Electoral Commission to conduct by-elections to fill the vacant seats which they, willingly on their own, decided to give up by defecting from the party they belong to, where they won election on, to another political party. If the lower court entertains such a matter, it will amount to judicial rascality and with its attendant implications for the growth and development of democracy in Nigeria. Nigerians must resist the planned judicial rascality in Rivers State. The plan by these 27 defected lawmakers must be resisted by all and sundry. The lower courts must prove to Nigerians that the judiciary is the dispenser of justice, protector of the rights of the people, and guardian protector of the Constitution of the State of Nigeria. Also, the judiciary must not allow politicians to truncate our nascent democracy, which has been running for the past 24 years, not minding the ups and downs, the upheavals here and there, but at least it's been steady, on a steady course in the last 24 years. The implication of such will be an era of lawlessness, and no society, especially a society like ours, Nigeria, can experience growth and development in a lawless society. The Center for African Liberation and Socioeconomic Rights uses this medium to call on the lower courts to reject totally the overtures by these 27 defected members of the Rivers State House of Assembly. That is the stand of CALSER. Thank you all, and God bless.